This is an appeal in the matter of Syspal Capital Limited and Truman and another.
Mr Mundy, good morning.
Good morning, my lady, my lords. I appear for the Appellant, Syspal Capital Limited, my learned friend Mr Haylen, for the first respondent, Christopher Truman. The second respondent, Syspal Holdings, has taken no part in this appeal, nor did it take part in the proceedings below. Might I mention the timings?
Yes.
My learned friend and I have agreed that, subject to the court's approval, I will have an hour and 15 minutes, he then an hour and 15 minutes, and that leaves half an hour for reply if needed. We're treating that as a limit, not a target, and we hope we may be a little quicker than that.
Thank you.
The court will have seen that, leaving aside the question as to whether this is an appeal on grounds of law or fact, this appeal is on one issue, the correct interpretation of one sentence in the company's Articles of Association. And the facts set out in my skeleton argument in Core Bundle tab 3, page 16, the article, and the essential facts stripped down to their bare essentials. The article 11.3 I shan't read out. And the facts are these: that Mr Truman was an employee member, so much is agreed. He was an employee of Syspal Limited, the trading company. He was a director of Syspal Limited and also of Syspal Holdings Limited, its parent company. He ceased to be an employee of Syspal Limited in October 2022. He wasn't an employee then of any other companies, but he did continue to be a director of both Syspal Limited and Syspal Holdings Limited for a time. And the question is he deemed under Article 11.3 to have served a transfer notice? We on this side say yes, he is. He has ceased to be employed as an employee, and he did not continue in that capacity in relation to any other group company in that capacity as an employee. My learned friend says no, there's no trigger under Article 11.3 because he continued to be a director.
And the difference is the way in which you value the shares.
Exactly so, exactly so. And it boils down to the difference between fair value, capital F, capital V, which is pro rata valuation, ignoring whether the shares are a minority or a majority holding in market value, which takes that into account.
Yes.
Might I deal with my submissions in this way? My first proposition is that the choice of words supports our interpretation. My second proposition is that our interpretation is commercially coherent. My third is that the judge, Mr Justice Roth's reasons for preferring the first respondent's interpretation ought not to be convincing. And then may I leave until last the question of whether this is an appeal on grounds of law or on grounds of fact.
I think I can say now that certainly, speaking for myself, I consider that all issues that arise in relation to the proper interpretation and construction of a contract are questions of law.
I'm very grateful. It may be in that case that I deal, so far as I need to deal with that question, in reply. Might I invite the court to start with the Articles of Association, and they're in full in the supplementary bundle at tab 8, starting at page 63. So before I get to the critical words, on page 63 itself, the court will see a definition of employee member. A member who is also, i.e. as well as being a member, also an employee, consultant or director of a group company, with the exception of Mr A. Roberto.
At the time of the articles were adopted, there could only ever have been one employee member, couldn't there, on this true construction? Because the other
Yes.
shareholder was a company. Yeah.
Oh, not quite.
That's always been the case, has it? Since the adoption of the articles, has that changed?
That's always been the case, my lord, yes. Then over the page, if we may, definition of group company is within the definition of group in the middle of page 64, and it's common ground between my learned friend and myself that Syspal Limited and Syspal Holdings Limited were group companies. And then on that page also the definitions of fair value and market value, which I've mentioned already. If we may then move through the articles to Article 10. There's the preemption provision, and this applies in and of itself if a shareholder wishes to transfer their shares, and that sets in train a process whereby the price of the shares is either determined by agreement between the shareholder and the board or by expert determination. That's Article 10.4. The shares are then offered to the other members, Article 10.2. And if the other members do not wish to buy the shares, the company may do so, Article 10.6. If the company does not do so, then the shareholder may sell the shares to any person the board approves of. This is this is Article 10.8. Approval not to be unreasonably withheld or delayed. But Article 10.8.1 places an important limitation on the members' right to sell their shares. The price for such shares is not less than the sale price. And then over the page, if we may please, on page 72, we get to the critical article, Article 11, which deals with deemed transfer notices. So this provides that in certain circumstances, a shareholder is deemed to have served a transfer notice. One of those, Article 11.1, deals with the death of a shareholder. 11.2, bankruptcy and like circumstances. And then 11.3 is the critical article.
So under clause 10, any sale where the price needs to be determined rather than agreed would be at fair value, unless we can leave aside 10.4.1, which is a very specific circumstance, unless it falls within 11.3. Is that right?
My lord, yes. So if it's a voluntary transfer notice, then value is fair value. And I'll mention this perhaps later. That has advantages and disadvantages for the selling shareholder. If there is a sale, the selling shareholder gets more money, but because the sale can't be at less than fair value, that may make it more difficult to sell the shares. Pros and cons. In circumstances where there's a deemed transfer notice, generally the price is market value, but there are three exceptions. So one sees generally market value, 10.4.2, three exceptions, death, permanent incapacity, retirement at age 65. Then it's fair value, and if it's death prior to the 10th of April 2024, the higher of fair value and £3 million. I'll come back to that in a moment, but since I'll mention it here, what I say is striking about the three particular circumstances, death, permanent incapacity and retirement, is that they're circumstances that the company can in some way make preparations for. In the case of death or permanent incapacity, by taking out key person insurance. Retirement at age 65 is something that's at least very predictable. As for Article 11.3 itself, on page 72, it begins, if any employee member, reference back to the definition that we've seen, shall cease for any reason. Words in the first set of parentheses are not critical to this dispute. To be employed as an employee, director or consultant. The word employed there, it's common ground between Mr. Halen and me, is not used in a technical sense of being employed under a contract of employment. It's used, in my words, in the sense of engaged as an employee, engaged as a consultant, engaged as a director. The word employee, on the other hand, in contrast to somebody who's a consultant, does appear to be used in the technical sense of employed under a contract of employment. So the contract contemplates that somebody may be employed, may be engaged as a director, may be employed, may be engaged as an employee, may be employed, engaged as a consultant. And the judge referred to the contract identifying three capacities in which somebody may be employed. On our interpretation, there's a trigger if somebody ceases to be employed as an employee, does not continue in that capacity as an employee. Trigger if someone ceases to be employed as a director and does not continue in that capacity, and so forth. I make two particular arguments about the wording. The first is this, that I say that the words in the second set of parentheses, and does not continue in that capacity in relation to any group company, make the position clear. The article identifies three capacities in which somebody may be employed, and the word that, the singular word that, is a reference back to the singular capacity in which somebody has ceased to be employed. 2 points about the word that. First, that it refers to something specific, and second, obviously, that it's singular, that, not those. And we say, what is that capacity? The capacity in which the employee member has ceased to be employed, and read in that way, the clause makes perfect sense. I accept that the clause might have been drafted such that it was much longer and said, if an employee member shall cease for any reason to be employed as an employee and does not continue in that capacity, does not continue as an employee in relation to any group company, or if an employee member shall cease for any reason to be employed as a director and does not continue as a director in relation to any group company, and so forth. But what I say is that this short wording says that in perhaps more elegantly, certainly in fewer words. And I say with respect to the judge that his reading of the article, my learned friend's reading of the article, turns the word that, singular, into plural, any of those, and does not adequately respect the words that the parties have chosen. The second point I make about the wording is this, that on the judge's interpretation, what Article 11.3 means is if a member ceases to be an employee member, then a transfer notice shall deem to have been served. And we say, if the draftsman had meant that, they simply would have said that. I appreciate Mr. Halen will make the point that I didn't make the specific point below, and he's right about that. But on a question of contractual interpretation, this court's not bound even to choose between the rival interpretations we put forward, never mind bound to ignore an argument, a consideration that wasn't considered below. Well,
Sorry, what was the submission then?
Forgive me, my lord. The submission is this, that on my learned friend's interpretation, there's a trigger under Article 11.3 only when somebody ceases to be, when somebody is no longer an employee, no longer a director, no longer a consultant. And my submission is this, that that amounts to this clause meaning, if any employee member shall cease for any reason to be an employee member. The draftsperson, when drafting this article, must have had the definition of employee member in mind, because they start with that definition. And so if the draftsperson had meant if any employee member shall cease to be an employee member, one would have expected them to say it. I appreciate that in any case, one side or the other, perhaps both, can suggest ways in which the drafting might have been improved if the other's interpretation were correct. But I do say that this is a remarkably maladroit way to borrow expression used in one of the authorities, to draft this clause, if that is what the draftsperson had meant.
So you say what it would mean would be if any employee shall cease for any reason if any employee member shall cease for any reason to continue in that capacity, etc.
Yes, or to be an employee member, something along those lines. But it could be dealt with in half the number of words and with its meaning being crystal clear. Though those points are, looking at the words, perhaps the most important thing to do, those are my points specifically directed to the language used.
While you're on the language, can I ask to look at 9.2, see if we get anything from that? 9.2 deals with a situation where a share is held by a member who is a director or employee. It doesn't include consultant, but it does include two of the categories. And they're allowed to transfer shares to a family trust or a member of the family. So if they do that, then without more, the preemption provisions don't apply. At least the provisions we're talking about don't apply. But you fall back into those preemption provisions by 9.2.1 in the event that such transferor ceases to be a director or employee of any group company. Now, the natural reading of that, I suggest, might well be, you're no longer a director or employee of any group company. So you cease altogether to be a director or employee. But that rather supports the judge's construction, doesn't it? Because you don't fall back into the preemption provisions in that case unless you've ceased for all purposes to be an employee or director.
one important difference between 9.2 and Article 11.3 is this will apply also to Mr Roberge. So it's not a perfectly parallel, because it doesn't use the definition of employee member, which excludes Mr Roberge. So it's not a perfectly parallel article.
Well, it would apply to him if he were to acquire shares. Doesn't apply, has in fact never applied, has it?
Correct.
Yes.
Correct, because his shares are.
So it could apply to anybody else. Well, I suppose Mr Roberge is the only one who's excluded from the definition.
Yes. Yes.
And why does that make all the difference?
Well, it only in this sense that there's no perfect parallel between the two clauses. Maybe I can say more on this topic. Having thought about it, this wasn't a point that's anybody's raised so far. I'll do my best, if needs be, to come back to that later. Then why is the interpretation? Why do we say the interpretation is commercially coherent and consistent with the contract read as a whole? Sorry, there is just, sorry, while it's on my mind, but back to, on Article 9.2.1, in the event that such transfer ceases to be a director or employee of a group company, it is, in my respectful submission, perfectly ambiguous. It could work one way or could work the other way. It could be that creates a trigger each time somebody. There's perhaps three ways of reading it. The first is that there's a trigger each time somebody ceases to be a director of any group company and each time somebody ceases to be an employee of any group company. The second, the other extreme is that there's a trigger only when somebody is no longer a director of any group company and no longer no longer an employee of any group company. And there's a middle ground, which is that it applies where somebody ceases to be a director of all group companies, therefore is no longer a director of any group company, and also applies when somebody ceases to be an employee of all group companies and therefore is no longer an employee of any group company. So, given that it's possible to read 9.2.1 in three separate ways, and we don't have the words in parentheses which steer us to which of those is the correct definition, my respectful submission would be that that's not a safe basis on which to, from which one could get much guidance as to the proper meaning of Article 11.3. Forgive me. Why is our interpretation commercially coherent? And I'll deal with this in three sections, if I may. The first is whether it's commercially coherent to allow the majority, the ongoing shareholders, to buy a shareholding employee's shares on his ceasing to be an employee, even if he continues as a director. The second is whether it's commercially coherent for a clause like this to apply even in cases of dispute. And the third is whether it's commercially coherent to allow the continuing shareholders to buy at the price described in the articles as market price. So, first proposition, that it's commercially coherent to allow the continuing shareholders to buy shareholding employee shares on his ceasing to be employee, even if he or she continues as a director. We say it's easy to imagine why shareholders might agree that if one of their number ceases to be an employee and therefore ceases to contribute to the day-to-day running of a business, that's a substantial change in the relationship, and the ongoing shareholders ought to be given the choice of buying that shareholder's shares at an appropriate value, to bring an end to the relationship of co-venturers, and perhaps to allow others who are going to be involved in the day-to-day running of the business to take a shareholding and the incentives that come with that. And it's equally easy to imagine that if somebody's brought into the company and given shares because they are a director, that they have a role in the strategic management, and they stop contributing to the company's strategic management, they cease to be a director, that's a sufficient change that the other shareholders ought to have the choice of bringing an end to the relationship as co-venturers. And the question is it commercially coherent if somebody's brought in on the expectation that they're both to be involved in strategic management as a director, but also to work day to day in the business as an employee? Does it make commercial sense if one of those things changes for the other shareholders to have a right to buy their shares at fair value? And I quite accept that different people in that situation may take a different view as to which is best, but we say perfectly commercially coherent for parties to think that just one of those changes ought to be sufficient. That, in a sense, is a theoretical answer to the question, but we can give a practical answer to the question because we know from experience that that is what parties sometimes do. And there was such a case, I've deliberately not cited more than one in accordance with the practice direction, but one such case is at tab 1 of the authorities bundle. That's the decision of Mr Justice Hoffman in RIA Company number 4377 of 1986. This was a case, one sees this from page 5 of the authorities bundle. This was a case about an electronic engineering company. The petitioner was somebody who says shareholder and somebody who says he was entitled to be the managing director, who brought an unfair prejudice petition. And what Mr Justice Hoffman was considering was an application to strike out the unfair prejudice petition. At the bottom, rather at the top of paragraphs of page 6 of the bundle, I hope it's read sidelined.
Yes.
There's Article 10 in the first paragraph, which, like ours, creates a trigger for a transfer notice. Slight difference in wording. It applies, one sees this 4 lines in, within 14 days of his ceasing to be an employee or to be such a director. And it's clear from that wording that if somebody simply ceased to be an employee and continued as a director, also if somebody ceased to be a director and continued as an employee, there would be under these articles a trigger. What happened in this case was that the well, I ought to mention, before moving on to what happened, that there was a qualification to cease to be an employee that we see in the following paragraph. And somebody doesn't cease to be an employee for the purpose of these articles of association if they're wrongfully dismissed or dismissed in circumstances where the employee wasn't in breach of contract. What then happened, one sees from page 7 at C onwards, is that the petitioner wrote a letter to the Times and 4 days later was summarily dismissed. And there was a dispute about whether the letter for the Times was the trigger for the summary dismissal or merely a symptom of the relationship having broken down. But he was summarily dismissed as an employee 4 days later, and about a month later, one sees this just above G, he was removed as a director. And it was argued that his dismissal as an employee was a wrongful dismissal, and that the articles ought to be interpreted. One sees this in page 8 of the bundle, in the sideline passage at the bottom of the page. The articles ought to be interpreted, rather there ought to be an implied term that an employee director who's been wrongfully dismissed was not obliged to give a transfer notice when he ceased to be a director. And then I rely on what Mr Justice Hoffman says at the bottom of the page. I do not regard the implication of such a term as seriously arguable. Some might take the view that it would have improved the fairness of the articles, and others might not. He goes on to explain why, even in these circumstances where somebody's not deemed to be, if there's no trigger notice, if somebody's wrongfully dismissed, it may nevertheless be thought fair that there's a trigger notice when they're removed as a director. So we say, both from theory but also from looking at practical examples, one can see that it's commercially coherent to have a trigger, even if a member loses only one of those statuses. My next point is that it's commercially coherent for a clause like this to apply even in cases of dispute. Indeed, I say that an article like Article 11.3 is particularly important where the relationship between the shareholders is broken down. Because on the one hand, that's exactly the sort of situation where shareholders may wish to end their relationship as co-venturers. On the other hand, it's just the sort of situation where they may struggle to agree a price. Company law doesn't generally, unless parties agree, doesn't generally provide for a no-fault divorce. And a minority seeking to end a relationship would otherwise only be able to do so if they had grounds for an unfair prejudice petition or just an equitable winding up petition. And even if the shareholder had such grounds, such petitions are notoriously expensive. The majority could only end the relationship by amending the Articles of Association to include a clause which allowed them to bring the relationship to an end. So what we say is that Article 11.3 provides a mechanism for a quick, cheap, and fair corporate divorce. Can I emphasise this, please? Because it's easy to think of examples where somebody may be removed as a director or dismissed as an employee for reasons which are inadequate, to put it mildly. This is not an exclusion clause. Nothing in this clause prevents an employee, if they consider themselves to be wrongfully dismissed, bringing a claim to the county court or high court. An employee, if they consider themselves unfairly dismissed or the subject of unlawful discrimination, to bring a claim to the employment tribunal. And for what it's worth, none of it stops an employer suing an employee for breach of contract or breach of duty. The clause doesn't wash away the history of the dispute if it gives rise to legal rights and remedies. All it does is allow an opportunity for the relationship as co-venturers to be put at an end.
Why does that help? I mean, the shares will be sold at a different valuation. I think everyone assumes a lower valuation. So is that done and dusted, or is there a way of reopening that? I mean, the judge found not as a matter of construction. What do you say about that?
In terms of whether a remedy in the employment tribunal would attack the... I say this, that if an employee could show that they'd suffered financial loss as a result, it may be very difficult to do, but if they could show that they'd suffered financial loss as a result, one would expect the employment tribunal or the courts to compensate them for that loss. If a concern that was raised below, if a dismissal were discriminatory, then an employee in the employment tribunal would be able to seek and would, in all reality, likely to obtain an award for injury to feelings. If they suffered financial loss, then they'd be entitled to it, but it may be very difficult to show. Particularly difficult to show because there was no obligation on the majority in any circumstances to buy at any price, never mind the higher price. Could I turn to the price, please, and deal with the question as to whether it's commercially coherent to allow a purchase at market price? Saw a difference between fair value, capital F, capital V, and market value. We say nothing unfair in taking account the minority status of the shares when valuing the outgoing shareholders' shares. And I say that firstly, if one likes, in the abstract, and then secondly, turning back to the particular provisions of these articles. In the abstract, I praeonate what Lady Arden said, given the judgment of the board in Shanda Games and Masso Capital. That's in the authorities bundle at tab 5. This was a case, one sees this from paragraph 1 on page 63, about Cayman Island merger law. And under Cayman Island merger law, a shareholder that objected to a merger, a shareholder that dissents, had an appraisal right, a right to have their shares bought at fair value, and that could be determined by the Grand Court. And there were two issues in the case. One concerned interest. The issue with which we're concerned, one sees identified in paragraph 25(1) on page 74. Whether the Cayman Island Court of Appeal was correct to hold that a minority discount should be applied in the determination of the fair value of the dissenting shareholders' shares. The Privy Council agreed with the Court of Appeal, and the summary of their reasons is at paragraph 29 on the same page. the particular reason which I rely on is the second. The general principle of valuation of shares on sale is that what has to be valued is what the shareholder has to sell. And Lady Arden, in her giving the board's judgment, returned to that or explained that in greater detail on page 77 of the bundle, paragraph 42. General principle of share valuation. The court should value the actual shareholding that the shareholder has to sell and not some hypothetical share. Then, if so much for the abstract, nothing unfair per se in a minority discount being applied, shares being valued for what they are. If one looks at the structure of this article, I touched on this earlier. If one looks at Article 10.4 in the supplementary bundle at page 70, one sees, although the Article 10.4, this doesn't come out immediately from its structure, one sees that one can draw a distinction between voluntary sales of shares under Article 10, where share value, the share price is fair value, and therefore the shareholder cannot sell unless somebody is willing to pay the pro rata value of their shares. As I said in answer to my Lord Justice Zacaroli's question earlier, that's an advantage and a disadvantage. An advantage to the seller because they will at least sometimes get a higher price, and perhaps it provides an incentive for the remaining shareholders to pay the higher price, but a disadvantage also because it may limit those who are able to pay. And one might expect that in the case of a minority shareholding, the practical effect of this is to limit those who are likely to want to buy the shares to those who are either associates of the majority or of the minority of the ongoing shareholders or of the leaving shareholders, because others would not want to pay for a minority shareholding a price that ignores the fact that they're buying a minority shareholder.
In effect, you're saying that the provisions that apply fair value are kind of a written water, because in a private company of this nature, the people who are going to want to pay fair value are few and far between.
Yes, that's one perfectly fair way of putting it. When it comes to the deemed transfer notices, so the event where the articles give an opportunity for the majority to buy the minority shares, the ongoing shareholders to buy a leaving shareholder's share. The price, except in 3 circumstances, is market value. And that's a price that the ongoing shareholder is much more likely to be willing to pay, because it's a price that takes into account that the shares have that minority status. And I say that makes sense because if the parties thought there are circumstances in which the majority ought to be able to buy the minority shares, ought to be able to have the choice of ending the relationship as co-venturers, it makes sense for the articles to provide a realistic price. for the majority to pay in those circumstances. Now, I accept that in some cases, perhaps in all cases, a price set in articles like this in advance may feel unfair to one side or the other. But difficult balances have to be struck. What's striking, I say, about this is that the three circumstances in which, as I said earlier, the three circumstances in which exceptionally on a compulsory transfer under Article 11, the employee shareholder is entitled to fair value, capital F, capital V, if their shares are bought, are circumstances in which the company is able to take steps to put itself in a position to be able to pay that higher value. And one can't say, of course, what the thinking is, but there's a certain logic to striking the balance in that way.
Slightly, your submission is based on the exceptions within 10.4.2, are they? The death, incapacity, and retirement. But there are other forms of involuntary transfer, aren't there? In clause 11. So 11.2, which would not result in market value. The only exception, the only circumstance in which 10.4.2 applies is where 11.3 results in a deemed transfer.
Yes, that's true, and the logic of that is less clear. It may be that in cases of bankruptcy, because of concerns about rules of anti-deprivation rules, that may have been the reason for the thinking of paying a higher price in bankruptcy. It's slightly odd that the higher price is payable in bankruptcy otherwise, because to whose advantage is it? If one imagines the parties drafting these articles, it's neither to the party who is made bankrupt nor to the others for the higher price to be paid. So it's difficult to see a particular logic to higher price being paid in that circumstances, I quite accept. So, so far I say the choice of words supports our interpretation, and our interpretation is commercially coherent and consistent with the contract viewed as a whole, bearing in mind, as been clear from this, that the certain degree of nuance and parts of the contract which are more difficult to explain. Perhaps that's all the more reason for concentrating on the words rather than trying to discern from the general scheme what the parties must have intended. Then, if I can turn to my third submission, which is that the judge's reasons for preferring his interpretation ought not to be convincing. And the judge perhaps had two particular concerns. One was concern about dismissals for no good reason, and the other was a concern about employees taking semi-retirement and becoming consultants. I take those in turn. Dismissals for no good reason, the learned judge dealt with in his judgment. This is in the core bundle, tab 7, page 63. The judge dealt with this in paragraph 30. And the judge says in the first sentence that this creates the potential for the employing company to dismiss Mr. Truman or an employee for no good reason in order to trigger a forced sale of his shares at the lower price. The first point I make about that is, for the reasons I've said, lower price. It's not something that ought to cause any judicial eyebrows to be raised. It's a price that parties may sensibly be thought appropriate for the circumstances. The second point about this is that the judge's reasoning on this point, I say with respect, fits awkwardly with his conclusion that it's not necessary to give the business efficacy to the articles to imply a limitation that Article 11.3 only applies on lawful dismissals. The argument was made below. One sees this in paragraph 18 of the judgment on page 60. The argument was made below. It's not renewed in this court. There ought to be an implied term in Article 11.3 such that the clause reads, if an employee member shall cease for any lawful reason to be employed as director, employee, director or consultant. And the judge dealt with that in his judgment at paragraph 36. And perhaps rather than me seek to summarise it, might I invite your ladyship and your lordships to read that.
Thank you. Yes.
Thank you. And I say there's a tension, there's an awkwardness about that. And this really leads to the third point, that there's little logical connection, in my respectful submission, between a concern about dismissals for no good reason and the judge's preferred interpretation. Because even on the judge's reasoning, if somebody were an employee and only an employee, and they were dismissed for no good reason, there would be a deemed transfer notice. And even on the judge's reading, if somebody were an employee and a director, and they were both dismissed for no good reason and removed as a director for no good reason, there would still be a deemed transfer notice. So there's a little logical connection between the concern about dismissals for no good reason and reading the article as the learned judge did. It may be that the judge assumed that an employee director, or perhaps Mr. Truman, could not be removed as a director. There was nothing in the material which is admissible on the question of interpretation of the articles to lead to that conclusion. There's nothing in the articles that constrains the shareholders' powers under section 168 of the Companies Act by majority to remove a director by ordinary resolution. And indeed, Article 18.1, this is in the supplementary bundle at page 76. Article 18.1 has specifically allowed the majority shareholder at any time from time to time to remove from office any director howsoever appointed. So the articles pointed in the opposite direction, allowing the majority to remove a director at any time. So the logic, the judge's logic of concern that somebody might be removed as an employee for no good reason, and therefore there would be a trigger, ought not to lead to a conclusion that therefore there should only be a trigger when an employee directors both removed as an employee and as a director. Explain that in a way that makes sense. I've phrased that carefully because I'm talking about the admissible material, because as matters worked out, there is an argument that as a result of a shareholder agreement, while Mr Truman could have been removed as a director of Syspal Limited, that may have left Syspal Limited in quorum. I don't want there to be any suggestion. I'm not telling the full story, but that is not admissible material, and so not something which can be a guide to the true meaning of the Articles of Association. The other oddity, and it's really the reverse position, is if the judge were right, if the judge were right to assume that an employee director could not be removed as a director, it would mean that on his interpretation, on my learned friend's interpretation, Article 11.3 would not apply to an employee director, even if dismissed for the most egregious and flagrant dishonesty. That employee, if they were able to, as the judge appeared to assume, able to cling on as a director, could avoid the majority bringing an end to a relationship as co-venturers. And that is, in my submission, at least equally as surprising a result. In paragraph 31 of the judgment, the judge said, this is perhaps just beyond halfway through the paragraph, the articles were clearly drafted to protect Mr Truman and his family's position as regard the valuation of his shares. He would receive fair value if he retired from all positions at 65 or through permanent incapacity. And he goes on to explain what would happen on death. And I say this part of the judge's reasoning is problematic for two reasons. The first is that it's simply not the case that Mr Truman would receive fair value if he retired from all positions at 65. All Article 11.3 gave is a right for the continuing shareholders to buy Mr Truman's shares if they wish to do so, and the company, if it wished to do so. There are no circumstances in which Mr Truman was entitled to require the continuing shareholders to buy his shares. The second problem I say there is with this part of the reasoning is that it recognises, at best, only one purpose to the structure, and there were at least multiple purposes. We say that the primary purpose of the relevant parts of the articles, Article 11, the primary purpose was to allow the continuing shareholders to bring an end to the relationship as co-venturers in certain circumstances. And it may have been framed in a way that operated as an incentive for Mr Truman to work to 65. It may have been framed with a view to operating as an incentive for him not to work much beyond 60, not to work beyond 65. But it's clearly not simply the position that the article is intended to protect Mr Truman and his family position, particularly since he's not entitled to have his shares bought even on death. There were multiple interests at stake, perhaps conflicting interests, and interests that were not perfectly reconcilable. And the conflicting interests are not just conflicts between the parties, but as I mentioned earlier, advantage and disadvantages for Mr Truman himself, for the articles to provide for the higher value or lower value, because if it's the lower value, his shares are more likely to be bought, and on his death, his estate is more likely to receive value, or on his ceasing to be an employee, he having cash in his hand rather than the shares in a company that he has no longer, he's no longer at the helm of. And I say, given all of those conflicting purposes, it's not helpful to try to discern a meaning to Article 11.3 by considering the purpose in the way the learned judge appears to have done so in this paragraph. While on the topic of dismissals for no good reason, I wonder whether it would be of assistance, and please tell me if it wouldn't, to deal with the parts of my learned friend's skeleton which might give the impression that this dismissal was clearly for no good reason. My learned friend deals with that. This is in core.
I don't think we need to go there.
I'm very grateful. I'm very grateful. Lots of dispute matter for the Employment Tribunal.
I'm sure.
My lady, I'm very grateful. Then can I deal with the judge's hypothetical employee taking semi-retirement? This is in the judgment of Mr Justice Roth, core bundle, page 62, paragraphs 28 and 29. And the judge appears to have taken this view, that if somebody ceases to be an employee, but then starts work as a consultant, there would, on my reading of the articles, be a trigger. And the judge appears to have considered that uncommercial. He says, paragraph 28, it's not uncommon for a senior employee to retire from full-time employment but continue to serve the business as a consultant. I do not see how commercial good sense suggests that in such circumstances an individual would be required to sell his shares, and to do so at the lower of the two valuations. Well, one might understand that in some circumstances where not much changes on the ground, one might consider it, in those particular circumstances, surprising if there's a trigger. On the other hand, there will be circumstances where the move from being an employee to being a consultant is a real substantial change in how much, the quantity, and also the quality of the particular shareholder's engagement with the day-to-day business of the company. It will all depend on the facts. And so, not necessarily, in my respectful submission, an uncontroversial result. It depends. But two further responses, if I may. The first is this. If one leaves aside employee directors becoming consultant directors, one reaches the same result on the judge's conclusion in my submission, because if somebody ceases to be an employee on a Friday and begins work on as a consultant even the next Monday, you would get the same result even on the judge's reading, even on my learned friend's reading, because that person would have ceased for a time to be any of a consultant employee or director. The second response is a more pragmatic one. There may well be circumstances in which it's thought by both sides that a long-serving employee should be a consultant, and it's desirable that they retain their shares continue to be incentivised in that role. If that's the case, then the parties can quite easily agree that that ought to be so. Whatever steps taken to put that formally so that there's no right for the majority to buy the minority share. It's much easier to do that in those circumstances where things are going well, by variation, waiver, whatever it may be. Much more difficult if things go less well. And Article 11.3 is, in my respectful submission, much more important in situations where things are going less well. So in sum, I say, the reasons given by the judge were not good reasons for departing from what I say is the natural meaning of the words used. If I may do so, I'll leave the question as to whether this is an issue of law to reply so far as I need to return to it. So unless there's anything that I can usefully add, those are my submissions.
Thank you very much indeed. Mr. Hayling?
My lady, my lords, if I can start where my learned friend just ended, and where your ladyship started, with the proposition that the contractual interpretation is a matter of law. You're obviously completely right in respect to that. But if I can take you to the authority bundle, it's page 129. It's Lord Justice Lewison and the textbook Lewison.
I'm sorry, page.
It's page 129 of the
Thank you.
authorities bundles, right at the end.
Thank you.
And as Lord Justice Lewison says, that where the ascertainment of the meaning of a written contract is a question of law.
You're reading from paragraph
4.09 at
Thank
the
you.
bottom of 129.
Yep.
which must be right. Many steps in the process of ascertaining that meaning are classified as questions of fact. He then goes on to quote Brutus versus Cozens in relation to the wording of the meaning insulting behaviour. And if I can just quote from that, it's not clear to me why precisely is the point of law which we have to decide. The question in the case stated for the opinion of the court is whether, on the above statement of fact, we came to correct decision in points of law. This seems to assume the meaning of the word insulting is a matter of law, and the divisional court appears to proceed on that footing. In my judgment, that is not right. The meaning of an ordinary word of the English language is not a question of law. The proper construction of a statute is a question of law. If the context shows that a word is used in an unusual sense, the court will determine what the unusual sense is. But here, in my opinion, no question of the word insult to be used in an unusual sense. Now, obviously, we're not dealing with statute in this, but it seems that there were, the analogy I used when talking at Chambers yesterday, if you excuse the analogy, is if the contractual interpretation, the meaning of the contract, is the secret sauce at the end, there are steps in terms of getting to that secret sauce, which are matters of fact, findings of fact, and this is dealt with in the next part of Lewison. If you just go over the page, top of 130, this distinction applies to written contracts in the same way. Nor is this approach confined to ordinary words at 410. And then at 411, the process of construction or interpretation, therefore, consists of at least two elements. One element of which is factual and the other legal. The two-stage process was summarised by Lord Justice Lindley in Chatney versus Brazilian Submarine Telegraph as follows. The expression construction, as applied to a document at all events, are used by English lawyers, including two things. First, the meaning of the words, and secondly, their legal effect, or the effect to be given to them. The meaning of the words I take to be a question of fact. In all cases, whether we are dealing with a poem or a legal document, the effect of the words used is a question of law. So I completely agree, my lady, with the starting premise. Obviously, in terms of the effect of a contract and the construction of a contract, that must be a matter of law. But to get there, to get to the secret sauce in terms of doing the ingredients that go into it, there have to be findings of fact. And there were findings of fact. And I'm going to illustrate what I would say were four important findings of fact, how Lord Mr Justice Roth got to his decision to find as a matter of law what the interpretation of the contract is. Now,
He started with the natural and ordinary meaning of the words.
Yes, which is and that's the first one. And in fact, an awful lot of what my learned friend's case is based on in respect of it is that question of the natural meaning of the word that as opposed to those. Now we'll get on to the articles as it happens. In I think it's 1.4 of the articles, it says the singular means the plural and the plural means singular, which is, as you'll be very familiar, is the usual boilerplate in such articles. But in determining that issue, i.e. what the meaning of the word that is in the context of 11.3, that determination is a matter of fact. The implications of that goes into making what the determination is as a matter of law. At the end of it, there were other meanings of fact as well. I'm going to suggest there were effectively four findings of fact. And the reason how Mr Justice Roth got to determine those core four findings of fact was obviously on the legal principles, where everyone agrees in this case that the judge followed the correct legal principles in terms of determining what the relevant issues were. And I would suggest there were four. One is, as you've already identified, my lady, is the ordinary natural meaning of the word that. Then I would say it's the ordinary natural meaning of the words within the context of the articles. And then I would say it would be the impact of the articles on the ordinary objective observer. The analogy he goes to in his judgment, obviously the articles would be up on Company House. Someone looking at the articles on Company House would not have, for example, the shareholders agreement, would not have other extrinsic evidence, wouldn't have, it would just have the articles and the company accounts, both of which are referred to in the judgment. And what would be the meaning of it within the context of that? That is one of the four areas of fact that the judge had to determine. He had to make a determination on what, based on the evidence that he looked at, and he had more evidence in front of him than you have today, because obviously it was for trial, what he thought that someone objectively looking at those articles would have interpreted the clause 11.3 to mean. And then
It's just that's a question of fact.
Well, it's a question of law that articles, and it's not in dispute, but articles have a particular interpretation in terms of contractual interpretation. And there's the Euro case that deals with that. The correct approach in terms of interpreting the articles is what would someone looking at it just within that limited context of what would be in Company House. But but in terms of determining what someone was likely to interpret that to be, in my submission, that must be a finding of fact. It goes to the law, obviously in respect of what the impact of that is, But this is, but I'm talking about in terms of Lord Justice Lewis and talking about the two-stage process. You have to determine what the ingredients are first before you determine what the law is at the end, and that is, I would say, the third finding of fact.
So that's the question. You say the finding of fact is as to what a reasonable person, having regard to what they could find at Companies House, would have thought the term means.
Yes. Yes, and no one's disputing in this matter, and there's the Euro authority that's in the bundle, that the law was correctly applied, i.e. that is a relevant consideration and the right consideration that the judge should have made. Effectively, though, what the position of the appellant is in respect of that is we just don't like the conclusion that the trial judge came to in respect of that. No one's suggesting, for example, in my skeleton argument, if you go to it's page 40 of the core bundle, and it's paragraph 64. It's not in the authority bundle, Henderson versus Foster, but obviously the court's going to be very familiar with the principle. Lord Reed said, in the absence of some other identifiable error, such as without attempting an exhaustive account, material error of law, or the making of a critical finding of fact which has no basis in the evidence, or a demonstrable misunderstanding of relevant evidence, or a demonstrable failure to consider relevant evidence. Now, no one is suggesting, in this case, that that's what's happened in relation to the court below. Effectively, the appellant's case is that the trial judge made an error of law in terms of his interpretation, the contractual interpretation. If my learned friend's case is, well, the trial judge came to the wrong conclusions in relation to those issues, the natural order meaning of the word, the meaning of the word within the context of the articles, the commercial context, and what someone looking at Company House would have interpreted the articles to be, which I would say were the four steps in the two-stage process before it's the rule of law. Even if, and I'm not saying the judge got it wrong, in fact, I'm saying the judge got it right, but let's say, for sake of example, he did get it wrong. And maybe my lords and my ladies, have you been trial judge taken a slightly different interpretation or a different interpretation in respect of those four matters of fact? That doesn't get, in my submission, my learned friend over the line in terms of the appellate court overturning a finding of the trial judge in relation to those four issues if they've been errors of fact, unless any of those three criteria apply. There was no basis in the evidence, a demonstrable misunderstanding of relevant evidence, or a demonstrable failure to consider relevant evidence. I don't think anyone's suggesting that. Certainly not suggesting my learned friend skeleton. I mean, it's obviously a matter for him in reply if he wants to put that forward. And this is why I urge the distinction. I would say it was more nuanced than my learned friend would suggest in terms of the way that this appeal should be approached. Yes, of course, the ultimate interpretation of the contract must be a matter of law. But what they're really complaining about, what this appeal is really about, is in fact complaining about that they don't like the findings of fact that the judge made in respect of those four issues. And those four findings are all the ingredients that went into what I've called the secret sauce in terms of making the issue as a matter of law of contractual interpretation of the implications of the contract. And the reason why, forgive my for labouring this point, but obviously it matters because it matters in terms of the test that you're going to set yourself when considering this appeal. It's not enough, I would say, to say, well, we might have interpreted it slightly different or even differently in terms of any of these points in the court below. The question is, in terms of the wide discretion that a trial judge has in relation to determining those issues, having the witness statements and the exhibits in front of him and thinking about those issues and making findings in his judgment in respect to that, if that test is not reached, then in my submission, this appeal must fail. Now, I'm not.
Mr. Hayden, how does that all stand? And I see what is said in Lewison at 4.09, but for example, at 4.08, you've got a reference to Sarah and Hussein Asset Holdings Limited and Black's Outdoor Retail Limited, which is the most recent iteration of the test in relation to how to interpret a contract.
Yes.
Follows on from Wood and Capita and all the others, and I think that's the main judgment is that of Lord Hamblin. And there it said at 4.08, the interpretation of the lease, in that case, the Supreme Court adopted a conclusion that hadn't been advanced by anybody, it hadn't been dealt with in the courts below. And it says, since the question of construction is one of law, it is at large. Now, I can quite see that the question of what an ordinary word means is a question of fact. But what we're about is putting that in the context of all of the rules about how to interpret the whole.
Indeed.
And that is a question of law. So the idea that we are bound, unless we can trip over the edge of he took something he shouldn't have taken into account, etc., by how, in effect, you would say, therefore, how the judge interpreted these clauses, can't be right, can it? I quite see that there's a tension here,
Yes.
but our job at the moment is the matter that is described in 4.08 as a matter which is one of law and is at large, and that's what we're doing.
And clearly the end answer must be, in terms of the contractual interpretation, is a matter of law. What the end result of, but it's how that's the answer. It's the question of what are the variables that go into the equation to come up with that answer, of which I would say there are a number of which are findings of fact, of which the core one in this case, and really what the core thrust of where the appellant is coming from in terms of his arguments and what he says in the skeleton is to say that should be those.
But I think you gave us three, or at least I've written down three,
Yes.
examples of what you say is fact, which is the ordinary natural meaning
Yes.
of that. You went on to say the ordinary natural meaning of words in their context.
Yes.
And the third was the effect on the ordinary objective observer.
Yes.
If all of those are fact, then what is left to be a question of law?
And the fourth one, which is the commercial context.
Yeah. So if all of those are fact, where's the law?
Well, the law comes in terms of the balancing exercise in between what your findings are in relation to those four stages. Those four factors are all part of the great balancing exercise in relation of what contractual interpretation is. Once the judge has made a determination on those issues, as it happens on all of those issues, we were successful at trial. But for example, he might have been more troubled in relation, say, to out of those four. We might have said three of those I'm happy with, one I'm less happy with. But in the balancing exercise of contractual interpretation, and you'll be very obviously familiar with all the different approaches over the years and the different ways that contract isn't that where the answer is the judicial balancing exercise at the end, to take all those factors into consideration and balance them up in terms of what the answer is in terms of the contractual interpretation. It just as it happens, in this case, I would say there were four core elements of facts. As it happened, the judge was convinced on all of them, which made the answer in respect of the final answer rather easy. If it had been less than four, if it had been 3 out of 4 or 2 out of 4, then the judge might have been more troubled in terms of his interpretation. So it's certainly not taking away the end solution in respect to this, which is the interpretation of law. That's obviously what the trial judge is there, and I won't go in, and you'll be very familiar why there's a historical distinction for contract between errors of fact and errors of law that goes back to jury trials and for judicial trials, etc., which Lewison deals with. My lady, and he also obviously says the right at the beginning in relation to that, the first thing he says in it's page 127, 401, and where he said that the headline, the proper construction of a written contract is a question of law, which no one disagrees with. However, the ascertainment of the meaning of a particular word is a question of fact. And then the division between what is a question of law and what is a question of fact is extremely difficult to draw. I'm not suggesting this is easy. We probably wouldn't be here if this was easy. But nor am I suggesting that it's the end of the road in terms of the judicial process to go, well, I found this finding of fact and this finding of fact and this finding of fact, and that's my job. It's absolutely not. That's the first stage of the process. It's then the second stage of the process is applying the law to it, doing the judicial balancing exercise in relation to a whole variety of factors, some of which will be legal, some of which will be factual, and that produces the answer at the end of it.
Okay, let's go on then.
Yes. Is there anything else in relation to that point? I mean,
No, thank you.
Yeah,
Let's go on.
yes. If I can get on to the articles themselves. Now, my learned friend's already taken you through with, in some detail, various provisions of it. I'll take you to it because I did reference how much turns on it is debatable, but if you go to page 66, it's Article 1.4. There is obviously the absolutely standard boilerplate provision that you would have seen many, many times in contracts and shareholders agreements and legal documents. References to the masculine gender include the feminine neuter and vice versa. Similar references to the singular will include the plural and vice versa. Because essentially what my learned friend is very much pushing you towards is a very literal approach to the construction of 11.3, very much turning on that question of that means singular, and if it was going to mean all three, it would be plural and effectively should be those. Now, the trial judge, Mr Justice Roth, did deal with that. In his judgment, he said, I've looked at the word that, and in my view, the order and meaning of that means that relates to all three, both employee, both consultant, and director. And then he goes on to draw the analogy that he thinks it would be strange, for example, if he ceased to be an employee, Mr. Truman ceased to be an employee. And the articles are all about Mr. Truman. Mr. Truman is, other than Mr. Robert Jock, the only named person in these articles. It specifically refers to him in what I think was called effectively the key man provision. If he died, there was a payment of 3 million, and it's in the judgment. You haven't got any evidence in front of you, but it's in the judgment that there was some key man insurance in case he died in relation to that. As you've already pointed out, when my learned friend was on his feet, he was the only natural person who was a shareholder in the company, the other shareholder being a legal person, being a company. If you go to the definitions in respect of, there is reference on page 65 to, at the bottom in the definitions, to a shareholders agreement. Now, I'm not going to trouble you much with the shareholders agreement for the basis that obviously someone looking at the articles on Company House is not going to have the shareholders agreement. For what it's worth, there was a good faith provision in the shareholders' agreement, and the shareholders' agreement we said would have applied. But I totally appreciate that someone looking at that in Company House wouldn't have been aware of that, wouldn't have known about that. So I don't press that point. In relation to the point about what is the standard way of dealing with the shares in relation to these articles, as has been pointed out, in most scenarios in these articles, it's all about the shares being sold at fair value. There are certain scenarios in relation to 11.3 where it's market value. And it's all very well for my learned friend to say, and he's referred to some of the authorities and authorities well, and he talked about the Section 238 case from Cayman, which, as it happens in Cayman, that's to do with public companies, normally with reflective shares on the NASDAQ in New York being bought out. It's a completely different analogy. But there's nothing wrong in principle with a purchase at market value as opposed to fair value, normally on a 994, as you'll all be aware. That the starting point in relation to it, if you're a minority shareholder, is that a minority shareholder discount would apply. No one disagrees with that. But we're not dealing with those articles. We're dealing with these articles. And in the context of these articles, the exception is in relation to 11.3, and a very specific scenario has been set out in relation to when that applies. So it's all very well, and I don't disagree with say there's nothing wrong in concept with fair value being applied, or market value being applied when you're a minority shareholder in many circumstances. But again, it's a question of the court determining it and the meaning of the words in the context of these articles and this company. And in relation to someone, go to, for want of a better word, the man on the Clapham omnibus, looking at the Company House and looking at the articles. And again, Lord Justice Roth deals with this in his judgment and what observations that someone would make. It would be very clear from the limited information that was in the articles on Company House that Mr. Truman was a significant shareholder. He wasn't a majority shareholder, but a significant shareholder in the company. But he was an employee of the company. But he was a director of the company. But the provisions that were in there were almost all entirely to protect Mr. Truman, say in the position that, say, he dies. That he's protected by fair value. Now, my learned friend's right in relation to his retirement at 65. There is no obligation for them to purchase the shares. There isn't an obligation, but it is still a protection for Mr. Truman, but that the shares, if they do wish to purchase them, they must do it at fair value. So, for example, say that they were to float the company to an IPO, or they were to sell the company to another party. They can't buy them out on the cheap at market value with a minority shareholder discount. And as again, it's in the judgment. You haven't got the evidence on it, but it's in the judgment. There's a rough estimate. There's about a £3 million difference between the two. The number doesn't really matter, other than it's significant. And if that's the case, the person looking at these articles objectively would look at those provisions to say, well, this is all designed to protect Mr. Truman's position in respect of parts of 10 and 11. 11 is to protect the company, for want of a better word, in relation to if Mr. Truman ceases to be involved in the running of the group companies. Now, right at the beginning of my learned friend's submissions, he took you, I think it was page 6, if I can just find it. Yes, to Ria Company. It's page 6 of the authorities bundle. Are you there, my lady?
Yes.
Yes. So it's just worth reading out again. It's a right at the top of 105 under Hoffman J, in quotations. A member of the company who has been in the employment of the company or any of its subsidiaries, who has been a director of the company, shall be bound to give a transfer notice in respect of all of his shares in the company within 14 days of his ceasing to be an employee or to be such a director. So the wording in that matter is effectively the wording. If my learned friend he is suggesting that it's either employee or be director, that's how the provision should have been worded, so that it should have been clear that it was not three, but any one of those three. Mr. Justice Roth talks about in his judgment a scenario where he would think it was strange that if Mr. Truman ceased to be an employee, continued to be a director, but say became a consultant rather than an employee, and says that's not necessarily unusual in business practices. And then the way my learned friend then wants to deal with that, say, well, they could have agreed a carve out in respect of that. I mean, that's with greatest respect a bit of a stretch in relation to say, well, there's a provision but doesn't make sense. Well, if it doesn't make sense, there could be an agreement between the parties and we can carve that out and agree that doesn't apply. For example, under my learned friend interpretation of the agreement, if Mr. Truman had continued as an employee, continued as directors of these two companies, and then become a consultant in respect of one of the group companies, and then cease to be a consultant in respect of one of the group companies, under that basis, under Mr. Mundy's interpretation, 11.3 is triggered. And even though he continues to be an employee and even though he continues to be a director, because he is saying that it's in the singular in respect of that. If it was to take the meaning that Mr. Mundy is suggesting in terms of natural ordinary meaning, he wouldn't need to be trying to retrofit parentheses after the three keywords. What it would say is effectively what it says in Rea Company. Either ceases to be an employee, ceases to be a director, or ceases to be a consultant. It doesn't say that. And again, Mr. Mundy, you have to admire the intellectual convolutions on it. But he says, well, if I were drafting it effectively, I would have drafted it better. It would just say employee member if Mr. Justice Roth is right and Mr. Halen's right. But that's not what was drafted. And it's all very well and good to say, well, the drafting might have been done in a better way. It might have been done in a better way, and if it had been done in a better way, no doubt we wouldn't be here. But that's why we have judges, and that's why we have the Court of Appeal in relation to it. But going back to the point in relation to the natural and ordinary meaning of the word, there is nothing wrong with the interpretation in my submission that Mr. Roth has put it both in the narrow sense, Mr. Justice Roth has put it in both in the narrow sense in turning to that relating to any of those three. That's a perfectly normal reading of it. And that is only reinforced by his next finding that looking at the articles as a whole and the context of the articles, for that is the natural and ordinary meaning of the word. And that again is reinforced by what I've called sort of finding of fact 3 and 4. Whether they're findings of fact is obviously a matter for you, but but looking at what's on Company House and the contractual interpretation of articles, and also general commercial common sense, all of which combine together in my submission. But it's very clear that the interpretation that Mr. Justice Roth came to was the correct one, the right one, and the natural one. In respect of the articles themselves, obviously 9.1's been raised, and the distinction in that. You've looked at 10.4. Also at number 18, Article 18 has also been mentioned by my learned friend. So I can just scroll down to it, which is on page 76, where he says, well, the majority shareholder may at any time remove a director. Well, they might be able to. They did remove him as a director, but that's so what? They didn't remove him as a director of SHL, which is no one disputes is a group company, and no one disputes that he was a director of a group company at the relevant time up to his retirement. So in my submission, nothing turns on that. My lady and my lords, in relation to the articles themselves, is there anything, because my learned friend went through it in some detail, is there anything that you particularly want me to address in terms of those articles or the construction of those articles, either in the narrow sense of 11.3 or slightly wider in terms of a document as a whole?
No, thank you. I think we've understood your submissions and your written submissions.
Now, taking, I think, what the Americans suggest is that is a Socratic approach. Is there, in relation to the other points, in terms of commercial context, in terms of interpretation of the articles from the Independent Observer at Company House, which seem to be the other two core elements in terms of getting to the final solution in terms of what the answer is a matter of law, in relation to those, or Mr. Justice Roth's judgment, is there anything in particular you want me to address in relation to those points that would assist you, which I'm very happy to do, or would you like me to take you through the judgments itself in terms of Mr. Justice Roth taking you through paragraph by paragraph, how he deals with that? I'm very much in your hands, my lady.
Well, I don't think we want to be taking paragraph by paragraph through the judgment, thank you. We've read it thoroughly. If you could just summarise precisely what you say about the elements and the potpourri at the end.
Indeed, mixing our metaphors. In terms of the question of the interpretation at Company House, again,
Sorry, you say in natural and ordinary meaning of the words is clear.
Yes.
And it's as Mr. Justice Roth said.
Yes.
Okay, and then we move on.
Yes. And then in relation to the commercial context for it, it wouldn't be unusual in a company where you've got a key member of staff, and I use staff loosely because obviously he was an employee and an officer of two of the companies as well, to have a provision in there, effectively an incentive provision for want of anything else, saying that if you are with the company up to your 65th birthday, and this is of course a man who'd been at that company, for want of a better word, man and boy, I think it was over 30 years. The company effectively worked his way up, and obviously was a key person within that company. In terms of the commercial context of that, the interpretation of Mr. Justice Roth goes is he accepts Mr. Mundy's submission, but clearly that must be aimed for someone who is taking an active interest or role in that company. And that's not the exact words he used, so I'm paraphrasing. But that's essentially what he's getting at. One can still have an active interest role, add productively to the company in the role as an officer, as one can be as an employee, or as someone changes from being an employee to being a consultant. And I would say in terms of the commercial context, it's quite clear that effectively this is a provision to encourage that Mr. Truman doesn't leave a company, there's a good incentive there for him to stay, and doesn't leave, set up his own shop, for want of a better word, his own company in competition, because he has a vested interest in staying in that company till his retirement age, because if he does, and they want to get him out, they have to pay fair value for him and not the minority shareholders discount. And in my submission, that's entirely in line with commercial common sense when you're dealing in a particular context of these articles, which are very much aimed at one person, which is Mr. Truman.
Well, they don't have to pay him anything, do they? If he wants to leave, he can do so. They're not obliged to buy his shares.
No, they're not. No, they're not. But say, for example, they were to sell the company or they were to float the company, then if someone wanted to buy in to the company, they couldn't get him out at a much cheaper price. It's dealt with in the witness evidence, and I don't really want to go into the witness evidence, but in terms of the values that are put in the company, Mr. Truman thinks it's worth more than they think it's worth. And if they do decide to go and float the company or be bought, then he would get bought out on a pro rata basis in terms of his interest if someone wants to acquire the company. What they can't do is say, we're going to get rid of you at market value with the minority shareholders discount. We now have 100%, and then we go and sell our interest at 100% to a third party. They can't get him out that way. Or, for example, if the company, there's provision that he's entitled to dividends. At the end of his time there, he'd be entitled to his dividends on a pro rata basis if the company's doing well in profits. Again, they can't, unless 11.3 is triggered, they can't get him out, if you excuse the expression, on the cheap in terms of market value, so that they can have 100% of the dividends. They have to buy him out at fair value. So in my submission, my lord, that provision is very much designed to protect Mr. Truman. Now, my learned friend has said, well, it works both ways. For example, if someone was to buy out, they might not be very happy if buying Mr. Truman's shares, a third party that is, not the company, and buying them at fair value. Well, then don't buy them at fair value in respect to that. The third party doesn't have to do that. If Mr. Truman wants to sell his shares to the company for less than fair value and more than market value, if 11.3 is triggered, that's a deal he can do if he wants in relation to the company, if no third party wants to buy it. I don't think the bankruptcy provision, I agree, it's odd. I don't think anyone was thinking when they were drafting this, we must be extremely fair to the creditors in a bankruptcy, one would imagine. But I don't think really much turns on that in relation to that. But in terms of the commercial context, I think there's an absolutely logical path of reasoning that Mr. Justice Roth follows in his judgment in respect to that, and very much to fit the particular circumstances of this case. In respect to commercial context, is there anything else that either my lady or my lords you particularly want to address me on?
No, thank you.
I note the time. Is there anything else in the wider context of things that I can address you on, either that's raised by my learned friend or that troubles you, before my learned friend comes back in reply?
No, but we leave that up to you. If you want to say anything else, that's fine.
Yeah, I'm grateful.
My lady, my lords, can I just start with two factual matters? Nothing turns on these, but I don't want anything to have come across in an inaccurate way. In answer to my Lord Justice Zacaroli's question about Mr. Roberjo being a shareholder, I've been handed a note to say that he was a shareholder of SHL until 2011. The articles came in 2015, so nothing at all turns on that, but I mention it for the sake of accuracy. The second minor such point is my learned friend said that the difference between market value and fair value is 3 million. He also said that's not significant. I agree with him that the amount isn't significant. We don't actually agree that the difference is 3 million. Nothing again turns on that.
I think he said the reverse. I think he said whatever the number was, it was a significant number.
Indeed. In fact, Mr Justice Roth said he caveats himself in his judgment. He said that the number 3 million was mentioned, but he said if he uses the word significant, I don't think it matters if it's 3 million or 2 million or 4 million. Significant in itself is certainly worth litigating about.
I hope it is.
Well, there's no disagreement between us then. Thank you. Then my learned friend mentioned, I've just got 2 more substantive points. My learned friend mentioned Article 1.4 of the Articles of Association, which is at 66, I'm very grateful, page 66 of the supplementary bundle. And in relation to that, and that's not a point that at least I spotted in my learned friend skeleton, not a criticism, but perhaps an excuse for me reading out something which isn't in the authorities bundle. In Lewison on interpretation of contracts, paragraph 5.127.
And we don't have that.
You don't have that, I'm sorry, and we can provide it.
Yes, if you would provide copies of that, thank you.
And if you'll forgive me just reading this out, as you don't have it. It said, so Lewison says, Section 61 of the Law of Property Act 1925 provides, in all deeds, contracts, wills, orders, or other instruments executed, made, or coming into operation after the commencement of this Act, unless the context otherwise requires, A, month means calendar month, B, person includes a corporation, C, the singular includes the plural and vice versa, D, the masculine includes the feminine and vice versa. It goes on, many documents, especially conveyancing documents, contain definition and interpretation clauses which, in effect, reproduce Section 61, such as ours. He says such clauses are quite unnecessary. However, Section 61 is designed to save verbosity and should not be used to change fundamentally the meaning that a clause in a contract would have borne in its absence. And so I say don't take too much from Article 1.4. It doesn't deprive the court of the usefulness of the choice of the word that over the choice of the words any of those. In relation to, and I hope you'll forgive me coming back on this point now, in relation to my Lord Justice Zacaroli's question about Article 9.2 on page 69, the supplementary bundle. I've already made the point that in my respectful submission, 921 is perfectly ambiguous, and the 3 possible interpretations of that. And while I say Article 11.3, where the ambiguity is resolved by the words in parenthesis, might be used to help understand what's meant by Article 9.2.1, the reverse isn't true. It's not helpful, given the ambiguity in Article 9.2.1, to use that as a guide to the construction of Article 11.3. I've already made the point that there's no perfect parallel between the 2 clauses because Mr Robergeau is included in Article 9.2 and not in Article 11.3. And as my Lord Justice Zacaroli pointed out, there's a difference in that consultants aren't dealt with in Article 9.2 but are dealt with in Article 11.3. The other oddity or difference is that Article 9.2.1 makes shares transferred to a family member or a family trust subject to the provisions of Article 10 at least on the literal interpretation, they're not made subject to the provisions of Article 11.3. Of Article 11 at all. So it's made subject to the provisions that a family member can't onwardly transfer that share without serving a transfer notice, and then only onwardly transfer the shares if the remaining shareholders don't buy it, the company doesn't buy it, and only at a price which is not less than the specified sale price. But it doesn't make a family member shares subject to Article 11. I accept, in a sense, it's a double-edged point, because it might be said that that's an oddity, and since it's said that I place great weight on the literal interpretation of the words, as I do, the edge of the sword against me is that I'm doing down the drafting of the contract. But in the approach in Wood and Capita, when one's considering the importance of the quality of the drafting, it's not so much the quality of the drafting of the clause as a whole, and it's always, or nearly always, possible to find oddities in a contract if one looks carefully enough. It's the quality of the drafting of the particular clause in question, and the criticisms which one, or the oddities which one might identify in clause 9.2 are not found in Article 9.2 are not found in Article 11.3.
So your proposition is that because of that, Mr Truman could have avoided the consequence of his shares being purchased at market value on his ceasing to be an employee. He could have avoided that altogether by the expedient of transferring the shares to his family member or family trust. Because 11.3 doesn't apply. 9.2 doesn't. 9.2.1 doesn't refer to Article 11.
Well, I don't think I go that far. I think I would say that to make sense of Article 9.2, one has to read the reference to Article 10 as a reference to Article 11.3. My proposition really is that because of the difficulties in a number of respects with the drafting in Article 9.2, that's not a safe guide to the meaning of what I would say is a better drafted article, Article 11.3. That's my proposition. My lady, my lords, would it be helpful for me to come back on the question as to whether this is an appeal on a question of law or fact?
No, thank you, we're content.
Thank you. Might I just turn my back a moment? My lady, my lords, I'm most grateful.
Thank you very much indeed, and thank you for the helpful submissions and for all the support of those in the row behind. We will reserve our judgments, and in the usual way, which I'm sure you're very familiar with, they will be circulated in our form for you to comment on only as to our grammar and typographical errors and any obvious mistakes of fact, but not to re-argue any points. Thank you.
If I could just, hopefully I'm not breaching protocol by saying this, but could I give my hearty congratulations to my learned friend who took Silk last week. I think it's not his first hearing, but I think it's his second hearing. Silk, so.
I will come to that. Thank you. Thank you for reminding me. Also, you will appreciate that those drafts can only be circulated amongst the appropriate people whose email addresses have already been provided. If you want to widen that circle, please ask rather than doing it, because we take that extremely seriously. You will also appreciate that we hand down judgments electronically and that you won't have to return here, and that we also ask you, if you can, to agree an order in relation to the consequential matters once you see the drafts, and if you cannot agree, that you make very short written submissions in relation to your differences, and we will decide those on paper. Thank you. And I also extend our congratulations to Mr. Mundy, and I hope he has a long and successful career.
All rise if able.
Section 43 case in Court of Appeal. I'm not sure how patients they have.
So that's it. As in when they see fit, they'll come back to you with the result.
Tomorrow could be in terms of, I think the Court of Appeal is a bit quick.
Yeah.
The stream might still be on. Robert, are you heading back up north straight away?
Yes. I think
You're not going to hackle Stephen in court 69.
no, I'd like to.
I don't envy him being against a litigant in person in the Court of Appeal, but I mean that's.
No.
I don't envy anyone against being a litigant in person, quite frankly.
No, sorry.
It hasn't happened to me for a long time.
Well, I had a trial week before last.
Right.
Last week, I've lost track. No, week before
Yeah,
last.
against a litigant in person.
Against this person for 2 days.
In,
He was actually very courteous, I have to say.
but you said he was a solicitor.
No, he was
He was a genuine layperson.
He's the
Well,
one who's very interactive.
he was in fact a magistrate, so he wasn't completely
No.
out of.
Yeah.
But no, he was very courteous actually, and just
No, I'll sort. I can't. I won't. They had to rush to point.
The guy who normally turns up.
We can go and have a debrief.
Yeah.
Yeah. Yeah.
The original one.
We don't really have any room here at all. If you do need my clerks to come,
No,
I can arrange it.
No, I was only going to suggest if they were coming down anyway. It's fine.
No. A little bit short staffed today, and I didn't want to be too much with you guys.
Sorry.
That's right. But then I say if there's a problem, I'm very happy to ask. Robert, can I introduce Natasha?
hello.
Natasha Rose-Walsett, who is at bar school. So the misfortune of being mentored for 4 years now,
Yeah.
and
Around
even more misfortune being interviewed by your chambers last night.
Oh right. Oh, very good. Yes, I heard there was some interviews going on. How did you get on?
Yeah, it was really interesting. The questions were really made you think, which was fun.
Good.
But,
And what area you said?
yeah, commercial,
let's go
business
for-
property.
Let's go and chat to the client.
Oh, super. Well, best of luck.
Thank you very much. Nice talking to you.
Nice to meet you.
So who do you know who interviewed you? Something else or something?
The names have flown.
Who did your advocacy exercise?
Again, the names. Go on.
Right.
Yeah, Samir was there.
Samir, right.
And then,
Do you mind if I just put that on right there?
trying to help.
Yeah, just shut it up.
And there was a lady, long hair, bob.
Yeah, that's anyone in our group. They could be people cross groups. Robert, do you get involved in the pupillage stuff at all?
No, not. I used to be under committee. I haven't been for.
I got roped into it.
Years.
I think that's everything.
I think it's one of the most fun of the jobs that
Well-
you know you're expected to contribute something.
Yeah, the interview bit's fine, but I have to find the sifting. I was
It's
at a,
quite dull,
yeah, that took,
but it's
and I found in 2 applications in our sifting, people had left ChatGPT literally logos in their answers with GPT says. Funnily enough, I didn't get an interview.
No, it's a bit like when we receive applications that mention the wrong firm's name.
Yes, it's my dream. It's my dream to come and work at. Wonderful. I'll come and we'll clear out.
nice that you take care.
Yeah, you take care, Robert. Good to see you. Okay. I think that is everything. Thank you very much. You find it fascinating. Yeah, it was quite dry that. We got another one. I've got another one in the Court of Appeal, but I still don't know the date. Called DRAL, Service Terminal versus DRAL. It was going to be in the Court of Appeal suggested the 9th of May, and one of the other parties, not us, I think said they can't do the 9th of May, but I don't know if it's something that's come across your radar.
We find out what case we have a day before.
Do you?
Sometimes we see rumors and things.
Yeah. Right. Thank you very much. Have a nice day.
Thank you very much.